Excellent.
My savior.
Okay. So everybody, officially welcome. Thank you for joining us on this beautiful afternoon. For those of you who don't know me, my name is Adara Goldberg, and I'm the director of the Holocaust Resource Center here at Kean University. I'm very excited that you're joining us for today's program, 70 Years of German Compensation Law, Germany's Responsibility for Victims of World War II and the Holocaust. Our guest speaker this afternoon is Dr. Avraham or Avi Weber, who is a lawyer who specializes in German and European law. Since 2008, he has been the consultant to the Ministry for Social Equality, chartered by the Israeli government to negotiate with foreign governments for restitution of property and Jewish rights. He holds a double master's degree in law and obtained his PhD at Justus Liebig University Gießen in 2015. He is an adjunct lecturer at Avraham University in Israel, Philipps Marburg University in Germany, and is currently a visiting scholar at CUNY Brooklyn College. As of 2005, Dr. Weber has been a board member of the Israeli-German Chamber of Commerce, and as of 2010, a member of the Czech-Israeli Chamber of Commerce. And in 2012, he was appointed by the Tel Aviv Bar Association to chair the Czech Tel Aviv Lawyers Friendship Association. And I will now turn things over to Dr. Weber to get started.
Thank you very much. I hope that you can hear me well. And so today's talk or today's lecture is going to focus on 70 years of German compensation law, but mainly from the German perspective. So we're going to try and have a look, or a critical look, at the all the development that has happened over the last 70 years in the matter of compensation, and try and see how things are from the German perspective. I would start first with the talk, and then of course we'll leave time for questions at the end. And if there's any further interest after the talk, then I will be able to share also some articles and some information with the help of Dr. Goldberg. So now let me just try and begin. At the aftermath of the Holocaust, the German government had to come to an understanding of how to deal with the issue of compensation of the Jewish victims. The issue of compensating of victims, post-war victims, is usually dealt with on a bilateral level between states and is never the concern of the individual victim of the atrocities. States, as a part of international law, deal about these issues among each other and decide about creating a general compensation program that is run usually by the state itself. In the case of compensation of Jewish victims and what is the scope of the compensation, whether we are going to compensate only on physical damage, or are we going to compensate also on loss of property, loss of art, and issues like that. There was a very critical debate in Germany at the beginning, as it was unclear whether Germany should settle this Jewish issue in a separate way or as a part of its ongoing negotiations with the Allied forces as per the compensation expected from Germany. Very quickly into the game, the first chancellor of Germany, Konrad Adenauer, took or assumed the moral responsibility towards the Jews for the atrocities that have been done against them. In that respect, it was very clear from the beginning that Germany was going to create a new structure, or a new land, as you could say, in legal manners, to create and facilitate the ability of individuals to claim for their loss and for their damages. Germany, of course, did not do it single-sidedly. They were strongly pushed, convinced, hinted, or requested by the Allied forces to come to terms with their needs to accommodate the Jewish, so to speak, claim. And thus, the issue of compensating of Jewish victims became a highly important aspect in the puzzle that Germany, or West Germany, was trying to build in order to create some sort of a beginning of return to the nation, the family of nations. So the compensation became very early in the game for modern Germany, a crucial point in showing its change and its transition, mainly trying to create or separate the new modern Germany from its Nazi predecessor. I'd like to take a few minutes just to give you kind of a view of the internal situation in Germany post-war. Germany concluded the war completely defeated. The German term for the situation in Germany after the war is called the Untergang, which is the fall or the collapse of Germany. As early as 1943, the Allied forces already met in London and have agreed that the Jewish issue must be somewhat dealt in a separate way. The scope of the Holocaust and the specific targeting of Jewish nationals in Europe brought the Allied forces to agree already 2 years prior to the end of the war that in post-World War and in a non-existing Nazi Germany world, the successors of Nazi Germany would have to take into account creating some new structures to accommodate the wrongdoings towards the victims. Sadly enough, a contradicting vector was the beginning of the Cold War. Germany was very quickly after the war divided into two states. What we know as West Germany, it's the Federal Republic of Germany, and the Democratic Republic of Germany, it's basically the East German territories that were backed by the Soviets. And thus, also, in order to come clean or come to terms with the Jewish question, was not simple. Whereas the Jewish nation or those negotiating on behalf of the Jews with Germany had to basically approach two different entities. One, totally accepting or totally taking its responsibility towards the wrongdoings, and the other proclaiming to be basically the first victim of Nazi Germany, the state that fought the fascists, and thus East German narrative did not allow any room for compensation for Jews. One of the key elements that were clear to the German government from its inception was that one cannot have a country with a live, strong constitution recognizing civil liberties and rights, and at the same time not allowed to accept or not to receive the claims of Jews for the loss of their personal freedom, but at the same time their entire rights, starting, as I said, from property rights, but also intellectual rights and also other rights that are protected under the German constitution today. So simply saying the Germans didn't really have, West Germans didn't really have a way out of this issue, rather than to deal, as I said, with the individual claims of the Jews. At the same time, on the international level, we see various declarations that highlight the speciality or the uniqueness of the Holocaust. For example, the very famous Declaration of Prevention of Genocide, a treaty that was done in 1948, was predominantly following up a UN Council General Resolution of 1946, December 1946, where for the first time in history, the term genocide was basically coined. So we see parallel to the need to address the specific Jewish claims, an ongoing process in the international arena whether it is in the UN declarations, whether it is in the general wave of declarations, both on national and supranational level. Another good example is the 1948 Universal Declaration of Human Rights. So there is an ongoing process in post-World War world recognizing that there are civil liberties and personal rights that can never be infringed and should never be infringed. Once again, highlighting in a very focused manner the wrongdoings of the Nazis. This, of course, has developed over the years. I just listed here a few other establishments and agreements. It goes together with the development of the European Union and the enactment of the Charter of the European Union for the protection of human rights, and goes on with other international law treaties. When we come back, for example, for Germany, 1949, the Republic is being formed with the Basic Law. The Basic Law, as I said, entrenches 19 basic civil liberties to all those who find themselves on German territories. These rights are irrevocable and nobody can take them away from people, regardless whether they have a legal status in Germany or not. They are protected by the law. This, of course, once again came in a complete contrast to the situation in Germany during the Nazi regime, where in principle a dual state existed. A dual state means that there were laws for the citizens of the Reich that were Aryans, and all other were simply stripped of their definition as subjects of law, and thus could be basically haunted or stripped of all their rights. This situation, of course, was clearly something that was not to be accepted, and therefore the Chancellor, being heavily criticized of not taking a stand on this matter, held a State of the Nation speech where he spoke, and let me please translate the German wording. He speaks about unthinkable crimes that were committed on behalf of the German people. That sentence itself entails the complexity of the situation in Germany. It entails the fact that for the majority of the German population, it was still unacceptable to recognize the wrongdoings of the Nazis. About 11% of German population post-war, World War II, recognized the need to negotiate or to discuss some sort of compensation with the Jews. The vast majority, mainly touching into the dire economic straits situation of Germany post-war, said that Germany did not have the financial stability and ability to pay the Jews any compensation. So the Chancellor took a very clear stand on this position without even having the support of his coalition. So we're going to go in the next few minutes also to what agreements were reached, but it's important to remember that when the voting in German parliament came for the acceptance of the Luxembourg agreements that were concluded with the State of Israel and the Jewish Claims Conference, Adenauer did not have the majority within his coalition and had to get the support of the opposition to ratify these treaties. The main idea of the German government was to create, as I said, a new concept of allowing individuals, not legal subjects of Germany and not in the dispose of Germany, meaning in simple terms, non-Germans, to file personal claims for compensation and support from the Federal Republic of Germany. This meant, in a way, the creation of a second tier or an additional compensation system for the wrongdoings of the Nazis. And as I said before, it in many ways overlooked the bilateral treaties that were concluded after the war. And this meant that in many ways, citizens of third countries, not Germany, that their country in principle received some money as reparation, could submit their own basic claim to the German authorities. Germans, like Germans, decided to create a new Bible or a new codex for the issue of compensation, and therefore the BEG, which is the abbreviation of the Bundesentschädigungsgesetz, again, the German language likes to have very long wordings. It's the federal legislation for compensation of Nazi wrongdoings. And therefore, the law lists a range of heads of claims, starting off from infringement of personal rights, limitation of freedom, wearing of the yellow star, to invalidities that were due to Nazi persecution, but also go into very much details of the personal property looting of the Nazis, allocating funds for a restitution of or cash payments for artworks that were stolen, bank accounts that were robbed, insurance plans that were canceled, and so on and so forth. The scope of the legislation is also surprisingly very wide. There are indeed tiers or levels of persecution, starting off with the simple payment as a one-time payment, going into, in principle, to the scope of, just a second, just bounce. Okay. Going in principle into much deeper issues, but again, it was the attempt of the Germans to kind of lay out a very clear textbook of who's persecuted and what the payments are going to be. Soon enough, it was clear that this intention is not without issues, and you will be surprised that not all claimants or not all organizations involved in reaching out for these payments were happy with the legal definition and the systematics of actually paying out these pensions. So the federal government very quickly came to the conclusion that it should create some sort of a specific statute of limitation that was introduced in 1965, thinking that by the beginning of 1970s, all claims will be dealt with and there would be no need for additional payments. Of course, wanting something to happen doesn't automatically make it happen. And the legislation that was very simple in text, but very poor in the legal definitions, brought waves of claims to German courts, and thousands of court instances had to be engaged in order to clarify technical issues. Example, the definition of Holocaust survivor. This is, interestingly enough, up until now, still an unclear situation, an unclear legal definition. It's still an open book where year after year the definitions keep on changing. And at the time, the task of actually screening these claims was given to the civil administration and bureaucracy, and you can imagine how thoughtful, mindful, and sensitive the clerks were towards Jewish claims. And so from one end, we have on the academic projected idea of very interesting legislation that is very wide and open for many survivors to claim their claims. But in practice, the Supreme Court of Germany was swamped with cases of those trying to fight for their rights. As I said very quickly, after the 70s, the Germans decided to start embarking new ways of accommodating those needs. A new genius idea came into life, and that is to create an amendment to the Social Security law in Germany and recognize fictively persecutions as times that contribute to the creation of an old pension, an old age pension. This is, of course, a model that wasn't specifically done only for Jewish victims. It was a model that helped or was developed in Germany in order to create social security pensions for all deportees, Germans that were kicked out of Central and Eastern European countries after the war and came to Germany to live. And this once again created the structure was not accommodating in any manner the needs and the specific topic. We have to always remember with all the criticism that accommodating claims for a grave breach of almost every human right or every civil right that exists usually is a situation that is not common to the legal system. And thus, instead of creating a simple mechanism that defines the scope and the manner of the payments, all these systems were highly bureaucratic and complicated, and usually the usual litigation time for these claims was about 11 years. So at a certain point, even the Germans got the point, and as the early 80s came up with the idea to create a totally different structure or framework, and that is to engage the Jewish Claims Conference as a partner in facilitating the payments for survivors. Again, 1980s, we're speaking about a much bigger time spent from the war, and things are a bit less sensitive. And yes, the main groups of survivors that we know from Schindler's List received some payments and so on. But yet again, the entire engagement between a Holocaust survivor and a German bureaucrat never really came across as a very healthy or a interesting way of resolving the issues. Very quickly after the reunification of Germany, I'm taking us 1 second back to the beginning of the talk today. The reunification of Germany created a new opportunity. It was the opportunity to basically finish the unfinished business with East Germany, meaning to bring the East German part, which was a third of the Republic of Germany pre-war, to pay or contribute for the payments for survivors. As I said before, and we might be able to touch it up later in more details in questions, but I just want to refer to it and continue. The outcome of the Cold War was very tragic for survivors. The fall of the Iron Curtain created a line also in the matter of compensation. The Allied forces refused and sanctioned Germany not to pay any German marks to those living behind the Iron Curtain, proclaiming that it would actually pay out to the Soviet regime hard Western currency. And as such, survivors that were, let's say, stuck in Poland and have lived through the biggest of hells, ghettos, camps, and so on, could not receive a pension as long as they were under communist Poland, an issue that was again redressed only with the fall of the Iron Curtain and the reunification of Germany. The Claims Conference played, therefore, a huge important role in facilitating a huge amount of payments to a huge amount of survivors that were stuck behind the Iron Curtain. And thus, with the introduction of Claims Conference as a facilitator to the Jewish people, of course, the contact was much faster, as the Claims Conference had very strong ties with Jewish communities and was perceived to be less intimidating than the German normal bureaucrat. So in principle, it continues to be the engagement and the funds of the federal government from one end, but the payment mechanism and the payment system, it's done via the assistance of the Jewish Claims Conference. At the same time, I think that those of you who know a bit about the compensation and payments for Nazi Holocaust era might ask themselves a question about what I said before about rights of survivors, such as bank accounts, insurance companies, and so on and so forth. The reason that I am now addressing it is to kind of bring us into the beginning of the 2000s, end of the 90s, beginning of 2000s, where suddenly, interesting enough, wave of class action claims were brought in the United States against German institutions and German banks and insurance companies. This was all made possible with the enactment of the US Foreign Sovereignty Immunity Act of 1976, which allows any individual that was robbed of his civil right or human liberty by a third party country that does business in the United States, he can sue that country in the United States and argue that the sovereignty immunity should be taken and that the country should be paying out of its assets and profits of business in the United States. This legislation has over the years was used for two main lines of claims. One is claims against the Republic of Iran as of 1979 and trying to dispossess Iranian properties in the United States. And the second is, of course, the wave of claims related to Holocaust matters of the 90s that brought these civil claims here in the US. There were two main groups of claims. One was the claims against the Swiss bank, and it's named here in reference to Swiss bank litigation because basically after a long litigation process here in New York, the Swiss banks agreed voluntarily to come to terms with Jewish Claims Conference and other Jewish organizations as per the overall settlement to be reached regarding the issue of the Swiss accounts. And at the same time, the German main industry companies were at the same time also sued, most of them doing very good business in the United States. And so they were, both the Swiss banks and the German companies were actually forced to litigate and to come into terms with the claimants' organizations. Interestingly enough, this process has produced a new modality for compensations. We are already shifting into the fourth modality. Just to quickly refresh us all, the first was direct payments of the German government for individual compensation. The second was the attempt to create extra legal structures via the social security mechanism. The third would be the agreements with the Jewish Claims Conference to be a facilitator for this fund. And the fourth is creating closed funds to pay out individual compensations. This would mean, in simple English, the companies would pay out a certain X dollar amount that was agreed upon. This amount would be administered by a claims processing system, sometimes Jewish Claims Conference, sometimes not. And those claims would then go back to individual claimants. The idea was to somehow bring this issue to an end. And so for the claimants, they would receive a guarantee of the United States of America and other countries not to be further sued on these issues. So they received what we call legal peace for what they've done. And the claimants would have a very quick, non-bureaucratic, simple system to basically give out their names, their basic stories, and their intention to reach out for these funds, and then their claims would be relatively quickly settled. That is, of course, always the big challenge. Using my other hat as an individual lawyer, there's always a question what kind of an arrangement one wants to reach. Do we want to reach an arrangement that covers a maximum amount of people, and then, of course, they get smaller amounts in compensation? Or do we want to create an individual structure that would allow each and every person to fight and try to force his claim? You would think that by this point of our conversation, we would have basically covered all issues relating to compensation. But surprisingly enough, although the legislation that I'm about to speak about came to life in 2002, this legislation itself covered up until today over 85,000 claims worldwide. So the issue that was still open, the issue that was still discussed, is whether at all Holocaust survivors that were in ghettos and worked for the German industry, interestingly enough, an industry that paid out social contribution for their work. This sounds a bit weird the first time, so I will repeat it to make it even more ridiculous in the second time. This means that Jews that were brought into ghettos to die worked for the German industry, and because there was a law in Germany imposing a basic minimum contribution, social contribution for every worker, those contributions were sent then to Berlin because that was the law in Nazi Germany. And so the people that themselves were about to be gassed and killed, and nobody thought would ever see the money again, that created another revenue mechanism also for the German work or Arbeitsministerium back in Berlin. So interestingly enough, after many years of litigation, 2002, a legislation is brought to life, basically touching back on the Supreme Court decision in Germany from 1997, recognizing the ghetto industry, and thus creating the ghetto pension law, which in simple words, the allocation of normal social security benefits for Nazi victims that worked in ghettos. And the law itself, like we saw up until now, seems to be very simple. It speaks about A, the person, an individual has to prove that he was in ghetto. B, he has to prove that he worked. And 3, that he got some sort of a payment for that work. That's all needed in order to make sure that the structure remains a structure acceptable on the general compensation, social compensation law in Germany. And this, of course, as we've seen in the past, was never translated to something very practical. Holocaust survivors were denied of their rights because they couldn't show working agreements or working papers for the industry. Nobody was able to show the paychecks or the slips of payment or any confirmation of working contracts. And so thousands of cases were pushing their way up in the system until 2009, the Supreme Court in Germany once again adjudicated this issue and declared or simplified the questions at hand, and basically proclaiming that everyone that was together and freely assumed work should receive the pension. Anything given besides the minimum wage that was given to those who didn't work was to be seen as work payments, and thus the way became clearer for a payment of this pension. Just that we all understand, the last big decision of the Supreme Court on this issue was May 2020, where the Supreme Court has also defined the term of ghetto. This is brought for several amendments in the legislation over the years. So in very simple terms, yet again, a very big endeavor with very little success. So I just pointed out here the numbers. This legislation had about 95% of rejections over the years, 2002, 2009. And so immediately into this process, Germany found itself again being attacked or being against this attacked by countries such as the United States and Israel for in order to resolve this issue. Things became so crazy also with this legislation that after the chancellor met with the Israeli prime minister, she instructed the federal government to create a compensation fund for those who applied for compensation from the German government. Meaning, even at that point of time, 2007, instead of fixing up the problem, they created another mechanism that is supposed to offset further claims of the people. Okay, and now the next slide. Okay. So we're now slowly but surely, after rushing through 70 years of compensation, trying to come up to the first point that I would sum up and be more than happy to hear questions and to take questions. So we see that this process is an ongoing obligation of the federal government. It started already as the inception of the Federal Republic of Germany in 1949, ran up till basically, or still is up until today. Germany has never refused, maybe not being fully open, maybe not paying out everything, but has never refused to discuss or to hold negotiations about Holocaust survivors' needs. Over the years, this is very interesting. Numbers, and this is the biggest criticism that you always hear in closed rooms when you negotiate, the numbers of eligible Holocaust survivors usually grow. So although statistically with the age they're dying, more and more groups are being recognized, and thus still up until today, under the state budget of 2023, the allocation for Holocaust survivors needs grow. And it's less people that are with us, but they have bigger needs and they need more money and they need more support. And so these negotiations that happen on a yearly basis contribute to the extension of several programs that are there in order to help support them, whether it's in home care or in other needs of the survivors. The federal government has also created the strategic dialogue teams between the relevant parties in order to ensure that on a yearly basis there is an open dialogue as per the needs of survivors. So I think I'm coming almost to the last slide, and this is from a bird's eye look on this entire process. So the process, these are my personal remarks, so I'm more than happy to discuss them, but they're not something that is how do you say, it's not written in stone, and it's not given from God. So in my personal opinion, the 70 years of an open discussion between Germany, the Jewish people, with the Claims Conference and the State of Israel was actually very supportive of building a bridge between the nations. And so I would maintain that the very strong Israeli-German relations that are today could have never come to the point that we are today had it not been to the German assumption of responsibility and their ability to tackle and discuss a very critical and problematic question as to their liabilities. Parallel to the process of compensation, the federal government invested a lot of money into promotion of youth exchange in the 60s, so that the younger generation from both countries, Israel and Germany, would meet and be in a direct dialogue. And given here at the next bullet point, an example, today, if you want to sell or to do good business in Israel, you might brand the brand as a German brand, and the same opposite in Germany. If you want to have some fresh, new, hip color to your business, then you relate it or affiliate it with Israel. The key issue that I would maintain is just the main cornerstone of the relationships within the nation is the vast rehabilitation of numerous survivors. Over the years, the system has processed almost 500,000 survivors. Numbers speak about over 85 billion euros that were paid in individual compensations over the year. The ongoing dialogue between the side and the creation of additional support programs that are based on the actual needs of survivors again show where things stand. But not less interesting is the already proclaimed responsibility towards the future, perhaps not even less important than assisting survivors, is the ongoing commitment of the federal government to be an active player in fighting against anti-Semitism, but not less important, in the fight of the historical rightness of the memory of the Holocaust. So as we speak, tremendous thinking and budgeting of future programs in order to improve the study of the Holocaust and the narratives of the Holocaust, and to create some sort of a very stable base on which people can draw their knowledge in regard to the Holocaust. This is a topic that is highly important in Germany because it plays a very important role in today's politics. If we look into the current situation in the Ukraine, there it's pretty important to see that both sides use different narratives of the Holocaust, and therefore the moral obligation of maintaining that the memory of the Holocaust remains as close as it is to the truth, while at the same time, sadly, we're losing every month 30 to 40 Holocaust survivors. This is a strategic decision of the federal government that it will continue to engage and to work on this issue. If I'm not mistaken, this will be the time for me to ask for questions from the public.
Thank you so much. Adar, I don't want to take over if you want to, but I did
Please.
see a question in the chat.
Yeah.
Dr. Weber, if you wouldn't mind, can you briefly go over the 4 stages for claims and with discovery issues, if there's anything, with children of survivors, are there considerations for them to get claims, things like that?
So I'm not sure I got the question. If you can again try to explain it.
Sure. I believe you said that there was 4 different stages for claims. If you could go over those a little bit further, and are there anything such as, children of survivors, grandchildren, are there any avenues for them to receive compensation?
Right. Okay. So let's be very quick about the 4 different. I was speaking of the 4 different disciplines of law. The first discipline was the administrative law that was introduced in the 50s. Then we had the second one was the Social Security benefits. That was in the 70s. At a certain point, the federal government understood in the beginning of the 80s that it's unable to manage and deal with the claims for various reasons. It was very inefficient and didn't really pay back. So it was a lose-lose situation for the German government. And thus they reached out and connected with the Jewish Claims Conference in order to create a mechanism that allows a holistic solution to this issue, to make sure that people who make the claim see a physical person, speak to that person in their own language, and feel like their story is at least heard or dealt with in a humane way, and to mitigate these thoughts of Nazis coming back again and actually dealing with these claims. The 4th system I spoke about was this fund that you would engage in an international law claim against Germany, and Germany would support a settlement. The settlement would be a lump sum put into a fund, and that fund would then distribute the money to the eligible people. Now, when it comes to second generation, it's a bit tricky, because when you speak about second generation, the head of claims what actually is important. What do I mean with that? If we're speaking, for example, about looted art, there are no or almost none looted art claims nowadays being done by survivors. Most of them are their descendants, the family owners, people who received their rights for the painting via inheritance law. And as such, it's not limited to the person actually being alive. From the other hand, we saw that the main discipline that we discussed about was the personal injuries and invalidities. Personal injuries and invalidities is always mainly entailed with the person that was injured. So if I receive a compensation for being hit by a car when I'm dead, so there's no need to continue to pay. And in principle, what was woven in is the social principles saying that the widow or widower of the survivor, they were actually supported by the survivor. They kind of had a household based on the pension that that survivor received. So in many cases, the pension goes on also when the survivor himself dies and he has a spouse. Some of the structure fully, some of the structures for a certain amount of time, and some of the structures are with reduced scopes. Very interesting is the question about the rights of second generation. That again divides us into what we're claiming. So if we're trying to speak now about the personal invalidity of child survivors, then it's highly complicated because of the scope and the amount of potential claimants. So as we speak, the German government has agreed in very specific cases to allow second generation Holocaust survivors, kids, next of kids, to receive some support, mainly in the field of medical support, if needed, especially in the field of psychiatry. And so they basically opened up the programs that are already there for Holocaust survivors themselves, also to the second generation, saying that in very acute cases, the suffering has been so tremendous and been basically transferred. Another way that this was dealt with in the past was to allow also embryos to press claims. That sounds in a way strange, but the legislation nowadays allowed also those who were born in the aftermath of the Holocaust, up until 300 days after the liberation, to receive the same pensions as they would have received had they been alive at the time of persecution. Sorry. Both of what I just said today is thanks to a very developed legal jurisprudence proving medically the continuity of the damage. So the main issue of personal injury claims as a second generation is to actually prove that the damage is there. With the Holocaust survivors being directly in the Holocaust under Nazi persecution, it's rather simple to establish a hypothesis that people are actually injured or afflicted by what they've survived or what they've had. When it comes to the kids of some of them born many years after the Holocaust, it's problematic. I wouldn't say it's a closed chapter, never to be discussed or referred to in the future, but would be in any case something that would be dealt with on a very individual scope in a very limited way. Again, due to the vast numbers of people and the distancing from the damage itself. So I hope that was in a way clear as for the second generation. But if there are follow-up questions, I'm more than happy to engage in that.
Great, thank you. There is a question here. Can you further discuss the waves of compensation and contingencies for compensation?
Again, this is a very big sounds like what we spoke about with the ghetto pension law. Is the question, you would say, related to future things that might come, or okay? So I think that we're at the point where the main concern divides into two issues. One is the supplementary programs for individuals that are already recognized. This means something that we didn't have in the past. We understand that survivors today are much more needy in respect of their medical needs, social distancing, and other forms of support. And so we know that those who are still with us as we go have greater needs. And this is being addressed by global programs of the Jewish Claims Conference. As we speak, they're preparing for this year's negotiation. And so every year, supplementary programs come about to increase the support or the home care of the survivors, because people understand the survivors are much older and are non-mobile. So that means that services and help has to come physically to them and not being given out or in outer centers and so on. So one vector of your question would be, what's the future? So I would say for those still with us, it will be the consolidation of the servicing at the homes of survivors. This means from the psychiatric point of view, not only evaluation and medication, but also programs to fight loneliness and to bring younger people to homes of survivors to kind of engage them in conversations and some sort of a dialogue with people. The fact that many of the friends die is, of course, sad, but also creates again a more bigger stress on them. And all these programs are put out there or laid out there in order to combat that aspect. As for the groups of people, we've reached the point that most survivors are recognized one way or the others by systems. There is a very big group or very profound group of those who were mainly in the Soviet Union and fled from the Nazi occupation. And there is a yearly question of how to compensate them and how much to compensate them. Because clearly they were not under direct Nazi occupation, nor did they suffer from any of the satellite countries' persecution. But at the same time, they did lose everything and they did flee and they were in danger. So a group that was very close to the Nazis, for example, those who actually overlived the siege of Leningrad, they're already recognized as full survivors, and this is a relatively new group from the last 2 years. So to be totally frank, I would say that there are a couple of hundreds of people that are still, we call it, they fall between the chairs or they fall between the cracks, and so they're 95% being recognized and 97% recognized, and here we need the extra few feet to out of more responsibility and generosity to kind of bring them into the structures of the monthly payments. But I think that we are not expecting any huge new group of people to be recognized by the federal government as survivors. It has been almost 80 years, or now we're running closer to 80 years since the war has ended in many territories, and so the vast majority of survivors have already been addressed. Whether enough, whether this could be more, that's a different topic. As once a guy sitting across the negotiation table asked me, so what's life worth and what's the number one can come up with and be happy about? There is no number, and at the end of the day, life is kol haolam. We say that the one that saves one life saves the entire world. So it's very complicated when you speak about the amounts of payments to reach some sort of an understanding of what's been done. So there is some frustration by some groups, but then again, there are always the bigger number that are thrown in the air about the scope of compensation thus far, over 85 billion euros, and that's a big number. So, you know.
Excellent, thank you. There's another question. You mentioned that the framework of these reparation laws are being used in the United States in relation to Iran. Are there any other instances of the Holocaust reparations model laws being used as a model?
So wait a minute. First of all, it's about 50% true what was just said. Let me correct that. I was speaking about the Foreign Sovereignty Immunity Act. I wasn't speaking about German reparation structures. I said that the Foreign Immunity Act allows you to sue a third country in the United States doing business. And I said that the main two states being sued under this law were Iran and German or German related, such as Austria as well and Switzerland, both became very proud members of that club. And when it comes to modalities used, that's a very interesting field. And I thank you very much for already thinking about our future projects. We're actually now breaking off to meet my colleagues in Germany, where we are going to start this project that we're looking exactly into this issue. It's called Holocaust Remedies. And the idea is to try and stock take everything that was done in this respect and see whether in other international conflicts or needs to come to reparation agreements, we can use the vast information and knowledge that has been accumulated in this issue to create some sort of structures that would create personal compensation. So the answer to your question is yes, most definitely. In Germany itself, the legislation that the Claims Conference had in post-unification of Germany was the cornerstone of the payments for those who were persecuted by the social SED, they're called, by the East German communist regime, those who were put in labor camps and were put in sort of indoctrination camps in East Germany. And so, yes, that those legislations do set up as a benchmark for others. We've seen also a wave of Central and Eastern European countries, beginning of the 2000s, making their own legislation, assuming their responsibilities to what has happened to their fellow Jewish citizens that were stripped of all rights and protection. And again, it's very interesting to see that the legislation itself reflects the national narrative towards the Holocaust. So another very interesting field of discussion would be, how do these laws actually reflect national perception of the Holocaust? How does it entail the national victim or oppressor narrative towards the Holocaust? Where does this nation stand when it comes to matters relating to the Holocaust? And we see very vivid and very live debates as we go on in several countries. We just had a year ago Lithuania that extended its program for restitutions of property. So this is an ongoing issue. And just to connect to the question, yes, German model is always somewhere in the background as the golden rule of how to resolve things.
Thank you. Are there any other questions? You can feel free to unmute yourself or to type it into the chat. Okay. So on that note, thank you so much for making the time to come and speak with us today. I know there's so much to unpack and there is so much more work to do. But the hope is that you've just complicated things even more for us and our learning, which is what I'm always striving for. So thank you. And we wish you safe travels tonight. Yes.
Thank you very much for having me. And as I said, if there are additional questions, we'll be more than happy to accommodate them later on.
Excellent. Thank you very, very much.
Okay.
Great. So I'm going to ask my students